Hello, mic testing 1 2 3. Hello, mic testing. Hello, mic testing. హలో హలో జూమ్ చేసి హలో 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 మైక్ టెస్టింగ్.
Hello, hello. Hello, hello. 1, 2, 3, hello. Hello, 1, 2, 3, hello. Hello. Check. Hello, 1, 2, 3, hello. Hello. Check. 1, 2, 3, hello.
హలో హలో మైక్ టెస్టింగ్ 1 2 3 హలో హలో హలో
Hello, hello. Hello, hello. Hello. Hello, hello.
Hello.
hello, test, mic test, hello, hello, hello.
Pandey and before this tribunal in the today's dispute. 2.5 minutes permission to proceed with the submission. Not to defend its role, party autonomy before this tribunal, and the claimant, that is Indo, have seeked the joinder of my party autonomy in the present arbitral tribunal should be Aubrey Martel should be distantiate the first submission that why the present arbitral tribunal should be reconstituted under two limbs of my argument. Members of the tribunal, now coming towards my solution. Members of the tribunal, the arbitral tribunal derives its jurisdiction from the arbitration agreement between the parties itself and the titles of the contract itself, members of the tribunal. And additionally, members of the tribunal, according to Section 7 of the Arbitration Act,
was this an issue which was one of the issues made by the tribunal? And did you dispute?
tribunal under procedural order number 1 raised the objection. Respondent 2 has, and for the same reason over respondent 2. And for no, Madam Arbitrator, we are not claiming under respondent 1. We are the separate party which has been joined. We entered into the construction contract.
So it is directly related.
Somehow, Madam Arbitrator, we have to supply the BIPV facade system. It was necessary for the completion of the main construction contract.
Is that you knew that. You knew that this is the contract between. Maybe there is pity between you and the.
I understand the concern of members of the tribunal itself. I sense the concern. Even for a moment, members of the tribunal, respondent 2 is being dragged in the present arbitration proceeding without the explicit or implied consent of my client. But my client has been denied the principle of party autonomy. That is of cardinal importance. We agree, for a moment we agree, members of the tribunal, that without explicit consent my client has.
It's mutually destructive of the first. Your right to participate presupposes the right to be there.
I think put another way, does party autonomy, the argument of party autonomy, survive a finding that you are
Correct.
claiming through or under the
First respondent.
first respondent? That's the question. So does party autonomy apply even in cases where an agent of the respondent has been impleaded? So does party autonomy survive as a concept, or is there some concept of deemed consent?
I understand the concerns of members of the tribunal. We first of all, we are not separate arbitration agreement with respondent 1, and in the present arbitration proceeding, claimant and respondent 1 have seek the joinder of my client, and after that arbitral tribunal have allowed the joinder, and after that members of the tribunal we became a necessary party.
It's okay.
We became a necessary party in the present arbitration proceeding. So claimant has appointed his arbitrator. Respondent 1 have appointed their arbitrator. So what about the party autonomy of my client, members of the tribunal? Moving forward with my argument, members of the tribunal, according to section 18 of the Arbitration Act, mandates equal treatment of all parties, ensuring that each has a full and fair opportunity to present their case. This provision is not merely a guideline, but a mandatory requirement, leaving no room for derogation or deviation between the parties itself. Additionally, members of the tribunal, Chapter 5 itself, that is Chapter 5 itself of the Arbitration Act, deals with the conduct of the arbitral proceedings. Section 18 provides that parties shall be treated with equality and each party shall be given a full opportunity to present their case. Party autonomy is a fundamental, members of the tribunal, party autonomy is the fundamental principle in the in the international commercial arbitration, and for the same, each parties and with respect to that arbitral tribunal should, if you may please refer to page 33 of the MOOT proposition. 33 members of the tribunal.
Of?
33 of the MOOT proposition.
Or
Statement of defense by respondent.
all right.
Whenever the tribunal
Okay.
is
Defense by
ready. 33,
I'm a chota wala.
page 33, statement of defense by respondent 2, para 4. I made it the exact line. The council wants party autonomy. Primarily, we in the formation of this tribunal and has no respondent 1. We have objected party autonomy. We should be allowed to choose our arbitrator also, members of the tribunal. And for the same.
Isn't we give it over to an institution And those institutions then choose. Number one. Number two, participation in the appointment process. You are not objecting to the objective. See, as far as the conflict issue is concerned, it's cropped up now. Otherwise, other than that, there is no objection on the merits to that.
We agree that usually it is arbitrator, but in the very present
So
dispute,
considering that has only two parties, so are you going to pull everyone?
indeed, Mr. There should be reconstituted. There are two reasons for the same. First, the party autonomy has been denied to my client. We are arguing this, the cardinal principle of present arbitral proceeding, because, and this brings to me to my second submission, that the claimants appointed.
No, then I'll take it further. Now, for instance, you are afforded the chance. Then who goes out? The nominee of the second respondent goes out. Now, nobody has raised any objection to the nominee of the second respondent. Then the next step would be, you would propose someone, the first respondent would propose someone else, and who decides then? In law, who decides then? Please answer it rather than just.
As far I know, there can also
So it's a two monkeys fighting it.
way that we can go on to that. And before this
No,
tribunal,
I'm only saying that if you take it to the logical end, that is what will happen. If we rewind and say that the first look deeper of conflict. On the other points, he is their nominee. I mean, the claimant's nominee, but his nominee is not under any cloud table from the table, and can't have four. How do you answer that?
I sense your concern, Mr. Arbitrator, and for the same I have stated that not every party should be provided an opportunity, not
Exactly. So that's the point. That is the point.
But indeed, Mr. Arbitrator, in the present dispute,
Big objection to R1's nominee. That's the substance of it. Or is it just an empty argument that I want to participate? I want to participate. You didn't answer the question. The question posed to you was, do you have an objection to the R1's nominee? The first respondent's nominee?
no,
Objection? Yes, please move.
Mr. Aubrey Martel should be disqualified from the present argument. Now coming towards my first limb of argument, this arbitral tribunal, circumstances that create justifiable doubt against his impartiality and independence in accordance with section 12 of the Arbitration Act and
Of proximity to judge conflict of interest. There must be, what are the principles of law by which you will assess that there is a conflict of interest?
Madam Arbitrator, if there is justifiable doubt, the threshold of justifiable doubt needs to
What is that? Every
refer you to General Standard 2 on Conflict of Interest, IP Guidelines,
IVA guidelines.
2024, that is that says that doubts are justifiable if a reasonable third person having knowledge of the relevant facts and circumstances would reach the conclusion that there is likelihood that the arbitrator may be influenced by the factors other than the merits of the case itself, members of the tribunal.
See, the first level of disclosure is the relationship. That stands disclosed. At that point of time, of course, that was not objective. Investment that TFT has made in a rival company, a company which is a rival or a competitor of the claimant, I mean of the respondent. Now, is it a reasonable person's duty to examine and find this out? Is it publicly available, these investments? In the R1 did not, is it a reasonable position? That's what you have to answer right now.
And you can also use examples of some judgment or
Yes.
some case law that you have where it has been held that something akin to what is disclosed in the proposition here is considered conflict of interest.
Indeed, members of the tribunal. Firstly, I will try to
No,
substantiate
you can go straight to the case. There is no problem.
to the case. Court Association versus of Union of India. I'll state the one line what the Supreme Court held, which is related to the present dispute, that if a judge has a case of Central Electrification versus ECI, a joint venture company, the Honorable Supreme Court held that after the amendment of the judgment, Honorable Supreme Court held that if any Arbitration Act, then the arbitrator should be disqualified at the particular moment when the relationship has been disclosed. And members of the tribunal, in the present dispute, if I may guide you to page 34, para 9. The assistance of the tribunal, if I may read the exact line. Claimants' nominate of interest in international arbitration, claimants in this arbitration, since they have been money capital. Given that old money capital is funding, in page 30, members of the tribunal, given that old money capital is funding the claimants, any success for the claimant in this proceeding would directly benefit old money capital and by extension Ms. Tyrell.
No, but where is this in 7th schedule of the Arbitration Act, this relationship?
Where does
7th schedule of the Arbitration Act, which is in your compendium, please point which of these categories it falls.
if I may read the exact guide, affiliate of one of the parties, guideline number 13, the arbitrator has a significant financial interest in one of the parties or the outcome of the case.
In an employee. The second part, it says that this was an anonymous email. Now, how have you cared to verify the extent of the investment? There's nothing.
30 seconds.
But at his
Member, what does significant financial interest means? It has not been specifically defined. It differs from case to case. And in the present case, what if the third party funder, that is old money capital, promises an associate, Ms. Laurie Tyrell, that if Mr. Arbitrator will adjudicate the dispute in the claimant's favor, we will give a more profitable post to you, or we will give the promotion to you. This can also be a significant economical interest. And for the same reason, members of the tribunal, the present arbitral tribunal should be reconstituted in the light of the genre of respondent 2, and claimant's appointed arbitrator, Mr. Aubrey Martel, should be disqualified.
If I may start with the submissions, Honorable Tribunal.
yes, please.
A very good evening to the Honorable Tribunal and the other counsels present here. I am Gungun, present with my co-counsel, Ms. Yashika, and we are here today representing the interest of claimant in the present matter. As has already been highlighted by my opposing counsel, that there are 4 important issues in the present proceeding, under which I shall be dealing with the procedural issues and my co-counsel shall be dealing with the substantive issues. And both of us shall be speaking for 21 minutes, reserving 1.5 minutes for the rebuttal and sub-rebuttal. For my submission, Honorable Tribunal, I will be making certain contention for the interest of my client, and I will also be mirroring contentions which has been made by my opposing counsel. Starting with my submissions, Honorable Tribunal, my opposing counsel has contended about the lack of jurisdiction of this Honorable Tribunal. The reason they have given is that the jurisdiction comes from the very arbitration agreement of the parties. To this, I humbly refute by saying that if we look towards certain precedents in the Westerosi, it can be seen and be joined for the same, such as it was held in the case of Cox and Kings.
But I think that issue is no longer in dispute. The fact of joinder, he has not argued, we have not questioned whether or not he should be joined. We were told that's not an issue. So please go straight away to the constitution of the tribunal, which is what I'm saying.
Indeed, Madam Arbitrator, I will. Honorable Tribunal, I would firstly like to clarify the stand of claimant in the present proceeding. The stand of claimant is very clear as to that the claimant wants the respondent 1 to be liable for the project delays. If the tribunal may draw its attention to page number 10 of the MOOT proposition, which provides section 7 of the main construction contract. Under section 7, the very first paragraph, the very first line, it clearly states that it will be the builder, that is the respondent 1, who shall be responsible for the performance of all subcontractors engaged for the project. Honorable Tribunal, this clearly implies that even if the contract allows the builder, the respondent 1, to come up with any subcontract, even after that, the very clause clearly implies the intention of the parties to not make who will be liable, even co-counsel.
Then in that case, if that's your, why did you pull in?
Honorable Tribunal, if the
Are there no other ways of getting a fuller picture?
page number 29 of the MOOT proposition and proceeding, it states
request. At your request this has happened. It is not that the tribunal dreamt about it. No. Actor acknowledges the request for joinder submitted.
Accepted.
You accepted.
By the
Then
arbitral
the point
tribunal.
is there no other way for getting a fuller adjudication? Is there no other way? Please tell us. As a matter of general law, outside of arbitration,
If you could rephrase.
If you were not in the arbitration of
even
R2,
today, as I understand, you don't have a claim against respondent number 2. So claimant 2 is really in that sense a pro forma party.
Tribunal, the claim to understand all the facts and circumstances that has led to the project delays. And that
Council,
is
if I
why
may
this-
add one.
in which other way could you do it?
There could be other ways,
is
or is
there-
there no other way?
Is there another way you can bring the truth out about?
The other way could be that we can make respondent 2 as a witness also to the party. However, in our present case, since respondent 2 has attempted to shift his liability to respondent 2, that is why it becomes important that we include the respondent 2 as a part. Yes, indeed.
So even if he doesn't want to be there.
On the other hand, the initiation for client is the party who only, Mr. Arbitrator. Moving towards my other submission, principle of party autonomy, it is that respondent 2 has, for that, under, Madam Arbitrator, under one agreement. And the third,
Isn't that very different from them being dragged into a proceeding involuntarily?
I'm extremely sorry, Madam Arbitrator, I mistaken on the fact. It was actually the party to the arbitration agreement who sent the notice for the case. He sent the notice that he should be joined to the arbitration proceeding. And the court here held that the petitioner, the YSL, can be joined to the third party. That is why arbitration will not be imposed. The Arbitration Act held that principle of equality works as the mandate upon the parties as well as upon the arbitral tribunal to treat every parties as equal. But I contend that nowhere in the non-signatory to the party who is not even the party to
See,
the
look
arbitration.
at this R2, the second respondent who has raised this. This place, thereafter it makes this request. On it, I mean, why did it not? Maybe to sit together and have a common name, actually segregating it. In that case, during the proceedings also you can say, go ahead. Principle of equality.
First of all, it was respondent 1 liable. Come up with the procedure that one appointing each one of this particular procedure. Him to be a party. He is contending by giving the reasoning of the lack of due diligence maintained by respondent 1, and the respondent 1 and 2 are claiming. Though it will be substantiated by my co-counsel, I'm just telling it in brief. The ROC environmental protection, stricter standards that were there, and that is why I contend that respondent 2 is already having a representation in the present tribunal.
But panels, so it wants to put those panels. Continue with the project.
I contend that the inclusion of respondent 2 has happened findings. That is why it is important to against the claimant. To Honorable Tribunal pertains to the disqualification, and I will be contending it through senses.
No, before that part of the disclosure that you must make.
Coming to that, does not have the same
Does
to
the fact of third party funding not?
Madam Arbitrator had with the third party funder.
No, in paragraph 5, come to respondent number, does it disclose?
20 of the MOOT proposition. Was the involvement of claim against the respondent 1. And
Is the question. You disclosed it.
due to the disclosures has been made 1 and 2, and they have to party as well as with the submissions Honorable Tribunal Arbitrator, their which is parameter to apply the reasonable conclusion that the arbitrator is not tribunal relationship and puts a member who has only been disclosed being in a
Life partner, according to your member.
the threshold, there isn't any threshold, and she is only Madam Arbitrator in under.
Relationship. If you have been together.
I do agree to the point that they have
We don't know the number of employees. She has handled, I mean, what is their stand to, we are not sure. Mr. Martel, hey, what do you have to say? Isn't it something that he ought to have disclosed? Which leads to us to back to the section.
I do understand your concern, Mr. Arbitrator. The legal does not have a direct
Posing it as a partner, isn't that direct at the stage of every?
very reasonable third party, very far-fetched. I'd like to explain. If we apply the very Westerosi Arbitration Act, which is applicable here, it says that, its definition says that life partner, spouse, sibling, child, or parent are close. Even if we say that, if she is a close family.
Linear in today's world, relationship sometimes.
However, in the present case, we do not have a tribunal. In the present proceeding, include my arguments. Firstly, the recall attempt will lead to the violation of the appointed arbitrator should not be disqualified, which the respondent to has, which was necessary.
So she has taken.
What is the order now? So once
Question to my learned opponent. Secondly, Bharat Aluminium Corporation versus KSR Aluminium, in that party autonomy is a fundamental to Indian commercial reality. Party, first of all, my client has been drilled, then my partner has appointed arbitrator. We have
because you could have colluded counterclaim. So,
You're
that you are
trying to
working
get-
constituted.
I understand
And
your specifically between respondent 1 and respondent 2.
This is not really a big because you don't have fundament to get their person out.
You don't admit collusion.
Madam Arbitrator, if I
But there.
so party autonomy, we should be granted the. Secondly, my question, Oberyn Martel's wife is opposition, and if L, and I have also raised objection that 17 electrification held in the present dispute. This
In counsel for the rebuttal and to put forth my rebuttal for the same. First of all, as I have already contended, there is no shifting of liability. My client only claimed the liability. That is why, as I already contended, very law given under Westeros, the wife of Mr. Martel. It has not given between Mr. Martel and or whatever interest of the third party funder in the rival of respondent to. It is a very far-fetched relationship. Besides, my opposing counsel mostly entry 10 is or an affiliate in one of the funds. It does not come. Company is in one group of subsidiary company of the Honorable Tribunal.
As my co-counsel has substantive, it must be exempt from hereinafter referred to as Honorable Tribunal. The counsel for the claim not be exempt from any liability hardship in the intention of the parties and the important the government was definitely the very first paragraph would have been hit present case.
Time is never of the essence. Isn't that what the Supreme Court has repeatedly said?
Mr. Arbitrator, claimant would face 3 terms in the present case. That's why the liquidated tract, as the completion date has also been given in the as I was submitting by the UPICC to define when a suit.
You know, Titan standard. It's a business equal for you to import. A very restrictive category change in circumstance.
The importation did not put any restrictions on the import of such materials. It only increased the burden on respondent 1 to import that came. The council contends that
Certain, everybody knows.
Mr. Arbitrator, the council launched infrastructure. Mr. Sustainable
Yeah, but
infrastructure.
Your force majeure clause, equilibrium
May
fundamental.
I answer the question on the given the fact that the bank would that the BIPV facade agreed by respondent 1 in the that the it was these system give the rare earth elements and
in according to you, anything which is locally manufactured, not manufactured, but
the question that every law is foreseen. I do submit that laws in the kingdom of Westeros can be foreseen to a parliament and Madam Arbitrator
some vital information. You
whether claim
said that you could foresee.
no Mr. Arbitrator extent could have foreseen. However, regulations. This has been section 9, if I may read it for the permits and approval to predict for the
If you necessary, there's no obligation on you to happen. More so.
that claimant is not
Question. And to give extension of time to respondent number 1 due to this unforeseen circumstance that happened.
Madam Arbitrator, unforeseen. How conditions stipulated. If the tribunal may draw its attention to page number 5, paragraph number 14 of the MOOT proposition, it has been clearly stated to seek damages for the losses in the Baratheon, formally notified resolving the delay by date of the present two conditions. Had substantial progress if that satisfied the terms of the contract in the present case, Honorable Tribunal, when the very basis of the contract is shook, that the very rights and obligations of the parties in the present case have been materially affected. An onerous performance does not lead to a fundamental alteration, Honorable Tribunal.
Really? Because the time frame for completion is 4.5 years. Commencement date 15th May.
Mr. Arbitrator,
And the second question, at the time that you did you, this is indicate,
first question, that in the present contract, since time was of the essence, because the intention of the parties said so, the very fact that
no,
respondent
damages clause time is not of the essence.
In liquidated, not be
Madam Arbitrator, amount that that is why it is said present case, as the liquidated damages, as the time was of the essence, as the intention of the party said so. Firstly, second, circumstances the delays do. However, given the fact that by 13th May the contracts commenced on 15th May 2020 till 13th May 2004. In the present, secondly, that the surrounding circumstances, the commercial complex, construction complex was closely connected with the government project, shows that if there was any delay, therefore time was of the
And you,
under section 55 Honorable
Yes.
Tribunal of the Western Sea
did you
Contract
give
Act.
notice? That's why I asked you. Did you give notice? Time was lapsing and they had not performed. Either you extended the time, where is that mentioned in your problem?
The council would like Honorable Tribunal.
Where is that?
next line saying
He
if
asserted
you
was entitled, formally notified.
Yes, Mr. Arbitrator, that the extension was
No, but
given.
where is it? It says, I will initiate,
The above
if you
line.
see the 55, the third, but I'll claim damage.
Line says that in the present contract, that the enactment was, but the contract merely more to comply with the regulations, merely increase the burden of
go on to your next point.
responsibilities as the force majeure clause is not applicable. I may direct the tribunal's attention. If the builder that was given for assertion of for invocation of the liquidated damages clause in the matters of construction disputes, substantial completion or substantial performance, that all the material aspects of the contract, either, Madam.
The immaterial part really is the facade. The facade is not the material part then. How is it not substantially performed? The structure is put up, the finishing is.
Mr. Arbitrator, in the present case, the facade systems, which are the glass extension for 1 minute, it very simply. Therefore, the building cannot be occupied by anyone, and therefore, there is no substantial completion of the material aspect. The claimant that genuine pre-estimate of losses. This has the parties acknowledged this sum.
And even then, without injury,
On Mr. Arbitrator,
this associated builder
under has on the claimant because of the deal.
harm, or
The
is it just
One, under paragraph number 2, it's contractual.
suffered? Reputation is a matter of, cannot be just.
Page number 27, the newspaper report, there is no page number on that present page. The very last paragraph does show claimant does not concede to the newspaper report the things given out under the newspaper report. However, by the very newspaper report, it has been given that the closely connected with the Smart Cities program. Therefore, the broader initiative and the claimant's reputational losses were interconnected, and their tribunal is clarification number 27, wherein it has been clearly given that the parties, both respondent 1 and the claim, agreed upon during the contract.
What is considered as a pre-estimate. But that's as between the parties. The requirement of proof is still there if there is in every case, except when it is proved to the satisfaction of the court that it was impossible to prove injury, prove monetary compensation.
Because the project, as
Saying
I
that it might be paid news,
concede to what is laid out in the newspaper report, reputational losses,
probative value at all.
in this manner,
Yes,
we
yes,
can go
correct.
to the other.
present case, respondent to the enactment of, and secondly, there was no claimant is entitled, did provide 1 crores according to the liquidated damage.
Leave the preview. The first speaker is speaker one.
And claimant speaker one would thank your honorable tribunal.
Team members of the Arbitral International Construction Company. My client, Global Developers Private Limited. To bring to the attention of the Honorable Tribunal, my client, that is Al Majid International Construction, a leading project development company in the Kingdom of Budget worth rupees 300 crores. However, we have gathered here today as the respondent, that is my client, the claimant, that is my client, its liability due to the 90 submissions. Firstly, liability for the 91 day entitled to the. For my first submission, I shall present a twofold argument. Moving towards the first fold of my argument, in the instant case, indeed, there has been a 91-day delay in hands of my client qualifies as a force majeure.
Paragraph 14 of the MOOT new requirements. So only for this
14. Related to website was brought into public.
last overnight.
Number 13, that the subcontractor, if you may, claimant exhibit 1, the main construction of this act was on of website for a 300 crore per moment. If that website would be new documentation, Madam, BIPV, it's not what I'm would have been there, or the parties would have foreseen such an enactment, then the terms of that contract would have been according to that.
What they are not saying it's not a burden on you, but they're saying the burden is not of such an order to entitle you to protection under the force majeure clause. Please respond to that argument.
Firstly, at the time of contracting.
What, according to you, is go on. Sorry, answer the question.
Thank you. To refer to page 4, para 9 of the common case file. Regular site visits, weekly. Further, in the last line of the core structural framework of enactment of prior to the enactment of has induced a burden on the CERC if it directly common case file is prevented from performing its obligations, and that party shall be excused. Event that fundamentally equals 6.2. The performance in the present.
You didn't try to renegotiate it today.
Indeed, Madam Arbitrator, if you may please. You were unable to reach and know such which was unforeseen materials containing rare earth material. It was then are ethically sourced approvals and custom clear that any construction for the importation and the deployment. Now a question my client could have done the same. I would like to page 4, if the Honorable Tribunal may please refer to page 4, para 11 of the same, of the common case file. Here it clearly states that the facade installation finishing weatherproof for a moment 91 days was not exterior finishing affected shift, which was not just difficult but excessive. The subcon delays in the process.
As the builder. There's also no dispute between you and your subcontractability after having.
Forcing it from else is an easier option. Where else? Or if they initiate.
Even if this was an option for us, and for a moment would have.
Theory, because there could be compliances don't come. Safe companies which would have the capacity.
Separate subcontractor certificates which would have taken on these facts. The main construction doctrine of therefore we seek relief under the agreement which adjoint has acted in good faith. The main construction agreement to whilst the affected party, the court held that the affected party client has promptly communicated the highlight the duty of action aligned with the contractual and legal obligations, demonstrating compliance and cooperation despite the regulatory changes. This issue mitigate delays caused by the negotiating with Greenfuel, notifying the claimant via the as a reasonable time extension construction agreement, unforeseeable regulatory impact on the subcontractor. Yes. I would claimant has failed to
Signed it out. How is it bad in law?
the claimant has claimed that this penalty on my percent of the contract 91 crores that the burden of proof.
That's why it's different from the issue of like.
For a
How do you say because the 91 building it will attract putting
both the parties at this for this.
till after was the rent at that stage comes up in on it has to be some kind of
I do understand. Indeed, Mr. Arbitrator, how same lies on the burden extension of time. Page 27. If the which is a newspaper article shoots and spaces in Indo. Therefore, that this newspaper article, newspaper admitting the fact KSA does make it liable, that not so. or if they have actually suffered so, but attributable to the actions of my section 12 of the main variable, and that the delay is not shares a responsibility that the claimant is not entitled to receive this.
First of all, I would look in the present case as the same, was the very same case. Contract can never be that the be placed in the present case. Is on it did sit for next one to address the undermine the very as given under respond no cooperation or negotiation major clause under the present. I contended that the invocation.
May I answer? Case of energy watchdogs, I have clearly starting the duty of cooperation. In this present case, my client did cooperate with the claimant. It has sought for a time extension to adhere to the original, supposing the solution of this client has acted in claimant's country, which was imposing a burden to invoke the force majeure clause. The force majeure.
And fair, because some of the questions stake submissions in the gaps. But what you have framed is we have to answer made those who've been in practice. So the best, because sometimes you may be thrown off guard. That often we didn't answer. Just have to keep trying to have able people got looked at your. Thank you so much.